Wanted to talk about a recent case, Co versus Maxim Healthcare Services, that touched on negligent infliction of emotional distress and how this type of claim can be evolving in the modern era. Back in 1989, there was a case called Thing versus LEXIS, and it has essentially become the governing case for negligent infliction of emotional distress claims. It held that a plaintiff may recover damages for emotional distress caused by observing a negligently inflicted injury of a third person if and only if the plaintiff is 1. Closely related to the injury victim, 2. Is present at the scene of the injury producing event at the time it occurs and is then aware that it is causing injury to the victim, and 3. As a result, suffers serious emotional distress. It is the second of these injuries, the presence at the scene of the injury producing event, that was taken up in this recent case. Diana and Christopher Coe had a 2-year-old son, Landon, who had a genetic disorder which required him to have a feeding tube and require constant care and supervision. Whenever the Coes were unavailable to be present with their son, they hired Maxim Healthcare Services to provide them with in-home care for their son. In April of 2017, the Coes took their 2 older children to a youth basketball tournament. During the tournament, Miss Coe used an app on her phone to view Landon at home and see how he was doing with the in-home care that Maxim had provided. To her horror, she witnessed in real time Maxim's nurse hitting, slapping, pinching, and shaking Landon. She immediately called the police, gave them a copy of the video of the abuse. Maxim reassigned the offending nurse, but did not fire her. As a result, Landon had a lot of health issues and ultimately required having one of his eyes surgically removed. And unfortunately, he passed away about a year following the incident. While he was still alive, the Coes filed suit against Maxim, alleging claims for battery, assault, and negligence on behalf of their son Landon. They also brought a claim for negligent infliction of emotional distress for themselves, having witnessed the abuse via the nanny cam. Well, once litigation got underway, among other things, Maxim ended up filing a demurrer and a motion to strike the cause of action for negligent infliction of emotional distress, arguing that the Coes could not maintain this claim because they were not, quote unquote, present at the scene of the injury producing event at the time it occurs, which was that second element from the Thing versus LEXIS case. The Superior Court in Los Angeles actually agreed with that and granted the demurrer and did not give the Coes leave to amend. And that is how this case came about. The Coes appealed that ruling, and on appeal they argued that their virtual presence by using the phone through a real-time audio-visual connection satisfied the requirement in the Thing case of being contemporaneously there when their loved one was injured. The appellate court actually agreed and held that in the 3 decades since the Supreme Court decided Thing versus LEXIS, technology for virtual presence has developed dramatically, such that it is now common for families to experience events such as they unfold through the live streaming of video and audio. Recognition of a negligent infliction of emotional distress claim, where a person uses modern technology to contemporaneously perceive an event causing injury to a close family member, is consistent with the Supreme Court's requirements for negligent infliction of emotional distress liability and the court's desire to establish a bright line test for bystander recovery. And ultimately, they reversed the decision and remanded it back to trial court to be tried. So that's a new case discussing modern take on the elements for negligent infliction of emotional distress claim. If you have one of these types of claims, or you think you might, give us a call at Hiding in Irwin, 951-682-6400.